Regulation E is a hot topic once again in 2019. This can be a tricky regulation, especially when it comes to error resolution. In this video, we'll review some frequently asked questions regarding Reg E in addition to refreshing ourselves on the error resolution process. Among its provisions, Regulation E specifies procedures that institutions must follow for investigating and resolving errors alleged by consumers for electronic funds transfers, or EFTs, such as unauthorized ATM withdrawal. The regulation also specifies the extent to which a consumer can be held liable for unauthorized EFTs. When a member receives provisional credit during an investigation, can the credit union put those funds on hold until the investigation is complete? No. You must allow the member the full use of the provisional funds during the investigation. Once the credit union is made aware of an error, they must promptly investigate the matter and determine within 10 business days whether or not an error occurred. However, the credit union may take up to 45 days to conduct the investigation if it provisionally credits the member's account within 10 business days of receiving the error notice, informs the member within 2 business days after providing the provisional credit, gives the member the full use of the funds, corrects the error, if any, within 1 business day after determining that an error occurred, and reports the results to the member within 3 business days after completing the investigation. What if we realize that no error actually occurred on the member's account? In addition to the procedures we just went over, the credit union must include a written explanation of its findings when it reports the results of the investigation to the member. The explanation must note the member's right to request the documents that the credit union relied on in making its determination. Upon the member's request, the credit union must provide copies of these documents. When the credit union debits the provisionally credited amount, it must notify the member of the date and amount of the debiting, and that the credit union will honor checks or drafts or similar instruments payable to third parties and pre-authorized transfers from the member's account, without charge as a result of the overdraft, 5 business days after the notification. But the credit union need only honor items it would have paid if the provisionally credited funds had not been debited. What if our member is a victim of a scam and has given away their PIN number and/or CVV number from their debit card? Are they liable? Under Regulation E, negligence is not a factor in determining a consumer's liability for unauthorized EFTs. If the member notifies the credit union within 2 business days of discovering a loss or theft of an access device, the member is only liable for the lesser of $50 or the amount of money or property obtained through unauthorized use before notification to the credit union. If notification takes more than 2 business days after the member learned of the loss or theft, the member may become liable for not more than the lesser of $500 or the sum of the lesser of $50 or the amount of unauthorized transfers that occur within the 2 business days, and the amount of unauthorized transfers that occur after 2 business days and before notification, pending the credit union can establish that it would have prevented additional losses had the member provided timely notification. Even if the consumer writes their PIN on card or on paper attached to the card, the credit union cannot claim consumer negligence and impose additional burden on the consumer. MasterCard and Visa do have some different rules for chargeback processing in the case of customer negligence. Refer to the operating or chargeback rules for your branded cards. Please also note, credit unions can implement a policy to terminate any access device if a PIN number is found written on it. However, the credit union should not force repayment of the loss to reactivate an ATM card. It could be considered a violation of Regulation E liability provisions. So in conclusion, this is just a very brief summary of some of the error resolution rules found in Regulation E. For more detailed information, please see the resource links provided.